Hi, this is Eric Olson from Helps. I don't really know what to call this video. I could title it either, will a judgment creditor take my car, or deceptive advice sometimes given by bankruptcy attorneys. I could call it either one. So I'll tell you what the situation was. One of the attorneys here at Helps buzzed me a few minutes ago, had a widow on the line from Ohio who was very, very distressed. Her sister had given her a car that was worth $10,000 or more than that, somewhere in that range, a used car. And she had gone to a bankruptcy attorney because she had debt, and the bankruptcy attorney told her, well, you cannot file a Chapter 7 because here in this state, the exemption for a motor vehicle is like $3,700. And your car is worth $10,000. If you filed a regular bankruptcy, the trustee would take your car and sell it, give you the $3,700, and use the rest of the money to pay your creditors. So you need to file a Chapter 13. And if you don't file bankruptcy, one of these judgment creditors that has sued you and gotten a judgment, and they were credit cards, they're going to take that car, so you need to do this. Okay. I'm 71 years old, been an attorney for 42 years. Filed 40,000 bankruptcies. It so happened that when I was talking to this person, the other attorney was on the phone, my brother came in the office, and he's not part of Helps, but he's now the senior partner of the bankruptcy firm that I founded. And I asked him, and the person could hear me on the phone, I said, Lars, how long have you been in practice? He said, 31 years. I said, in bankruptcy the whole time, right? He said, yeah, that's right. I said, in 31 years, have you ever had an instance where a judgment creditor ever attempted to execute on a person's car that wasn't exempt where they had equity in it? And he said, never, not one time. Okay, so sure, it's theoretically possible, okay, but it doesn't happen for a lot of reasons. One reason is they'd have to file a writ of execution, they have to get a bond, a writ of assistance from the court, and there's ways to get it stopped. So these judgment creditors have learned by the rule of hard knocks that it's not worth their effort to do it. So they don't go after people's non-exempt personal property. But what disappoints me is for an attorney to talk to an elderly lady who's a widow, who's poor, didn't have a lot of money, and tell her, no, if you don't file, you can't file Chapter 7, a trustee will take your car, and if you don't do anything, the creditor is going to take your car because you got this non-exempt equity in this car that your sister gave you, and you have to file a Chapter 13. That was wrong, just plain wrong, lousy advice. More than lousy, deceptive advice. And it worked to that attorney's favor to try to get a fee from someone. He could have told her just what I said. I looked him up on the internet. I think he's been around practicing long enough to know better. He could have said, well, legally it's possible, but it doesn't happen in the real world. It just doesn't happen. And if they were, then you come to me and I know what to do, but it doesn't happen. So you don't need to file a Chapter 13, which would have really impoverished her by making a payment to a trustee, plus a huge attorney. Part of the payment would include his attorney fees. So occasionally I get disappointed with bankruptcy attorneys and the advice they give people. Not always, but occasionally. Attorneys have a responsibility. They know the law, but they also need to advise people of the practicalities and what happens in the real life and what happens and what doesn't happen. And just because something can happen you shouldn't run your life that way. For example, you could drive to the convenience store tonight at 10 o'clock. Do you worry about getting hit by a drunk driver? No. Are you going to get hit? Very unlikely. Have you ever been hit? Probably never. By a drunk driver at night? No, never. But it could happen. Okay. But then do you use that to tell someone you should not drive at night because you're going to get hit by a drunk driver? That's exactly what this kind of advice does, which is wrong. So, no, if you owe debt and someone gets a judgment creditor will try to get your wages if they can. A judgment will sit there, but they're not going to execute on your personal property. Now, if by chance they were, which will not happen, there's things that can be done, and that's when you can deal with it, but it won't happen. So why worry about it? But to push someone into a bankruptcy, making them think it's going to happen is downright wrong. Under the Federal Fair Debt Collection Practices Act, when a person has an attorney, debt collectors can no longer call that person or send them demand letters anymore. When people enroll in HELPS, we send what's called a cease and desist letter to that debt collector, tell him that we represent the person to receive communication, and they know they can no longer call them or send them letters. And then we also educate our clients on how they can maintain their financial independence. And that's, we tell them, what they need to do so they can remain independently financially. And one of those things is when they don't need to file bankruptcy. Frankly, for lower income, poor seniors, is very rare that they ever need to. There's exceptions. But using this as a reason to have someone to file bankruptcy, it's downright wrong. And if you have any questions, you can get on our website, www.helpsushere.org, or call us toll free at 855-HELPS-US. And please click on the button and subscribe to our YouTube channel. And you have a great day.